You're listening to the Quint's podcast.
On the day that the centre's new IT rules for digital media platforms were supposed to come into effect, WhatsApp took the centre to the Delhi High Court saying that its new rules would compel the messaging platform to violate the end-to-end encryption protections that it has set for its users. Now, the new IT rules or the intermediary rules have technically been effective from 26th May onwards for social media platforms which have more than 50 lakh users, for instance, Facebook, WhatsApp, Instagram, Twitter, and even the Desi version of Twitter, Koo. And two of the things that the government wants from social media platforms is firstly appointment of a grievance officer as part of a grievance redressal mechanism, and secondly, traceability. Now, traceability is basically the government asking social media platforms to trace the origin of any particular information that the government wants. For example, if you're looking at a forwarded message, who exactly started sharing the message? That's the kind of information that the government wants social media platforms to keep a tab on. And it's this traceability mandate that WhatsApp is opposing. The petition that was filed by the company on 25th May, which was the deadline date to comply with the new rules, invoked the historic 2017 Supreme Court verdict on the right to privacy to argue that the centre's traceability requirement is unconstitutional and against the fundamental right to privacy as upheld in the Puttaswamy judgment. And furthering that argument, WhatsApp has even asked the High Court to declare the said provision as a violation of privacy rights and also block any possibility of criminal liability against its employees over not complying the IT rules. But how exactly can this traceability mandate impact WhatsApp users? What is at stake here if WhatsApp loses this lawsuit? For this episode, we got in touch with Apar Gupta, lawyer and executive director of the Internet Freedom Foundation, and Mishi Choudhary, who's also a lawyer and the legal director and founder of the Software Freedom Law Center. You're tuned in to The Big Story, the podcast where we dissect the headline-making news for you. And I'm your host, Shorbori. That there's a growing struggle between the BJP-led centre and social media giants is as clear as day. While social media platforms like Facebook, WhatsApp, Twitter are all really invested in India given its large user base, in the recent days there's also been a lot of pressure on these platforms from two sides. While citizens are seeking corporate responsibility that ultimately led to actions like banning former US President Donald Trump from a lot of platforms, in India, there's also been a lot of pressure from the government to take down content that it considers as misinformation. And more often than not, such posts about misinformation have been the ones that also severely criticize the government's handling of the COVID-19 pandemic. For instance, only in April, the government had asked Twitter to delete tweets that were spreading quote-unquote fake news about the government's handling of the second wave. And because of the government's request, 52 tweets from people like Revanth Reddy, an MP, West Bengal State Minister Molloy Ghatok, actor Vineet Kumar Singh, filmmakers Vinod Kapri and Avinash Das were all censored. And recently, Twitter and the government came at loggerheads over the microblogging site's manipulated media tag for tweets that were posted by BJP leaders like Sambit Patra and some other union ministers that alleged that the Congress had floated a quote-unquote toolkit to malign the Modi government. For those who don't know, the manipulated media label means that the post has been quote-unquote deceptively altered or fabricated according to Twitter's policies. And Congress, along with some fact-checking websites, claim that the toolkit document shared by the BJP leaders is fake. But even as the government demanded that the manipulated media tag be removed, even as the Delhi police raided Twitter's Gurgaon office, the social media giant seems to have dug its heels. And now there's this lawsuit by WhatsApp against the centre as well. So what is making WhatsApp oppose the centre's traceability demands right before the deadline to comply by the IT rules? Let's take a look at what the Facebook-owned company wrote on a new post regarding this issue. The first line of the post says, and you can find the link to this post on the episode show notes, but the first line says that governments are seeking to force technology companies to find out who sent a particular message on private messaging services, and this concept is called traceability. But the traceability demand would break end-to-end encryption and would severely undermine privacy of millions and millions of users who use WhatsApp. We know that WhatsApp had brought in end-to-end encryption into the app in 2016, and this encryption ensures that calls, messages, photos, videos, and voice notes are all only shared with the intended recipient, and nobody else, not even WhatsApp, can intercept it. Of course, it's different from anybody physically catching hold of a phone and cracking any passwords and snooping in on messages, as we saw happening in the Sushant Singh Rajput case, where many WhatsApp chats were leaked to the media. Now, we know that in a separate matter, WhatsApp itself is facing users' approval for collecting and sharing user information and metadata with Facebook, as it has been doing since 2016. But in the IT rules about traceability, what WhatsApp fears is that it'll be expected to store much, much more user data that can lead to mass surveillance. And I'm going to read out a few lines from the WhatsApp post to explain where exactly the worry is stemming from. Quote, "That's because there's no way to predict which message a government would want to investigate in the future. In doing so, a government that chooses to mandate traceability is effectively mandating a new form of mass surveillance. To comply, messaging services would have to keep giant databases of every message you send or add a permanent identity stamp like a fingerprint to private messages with friends, families, colleagues, doctors, and businesses. Companies would be collecting more information about the users at a time when people want companies to have less information about them." End quote. Apar Gupta, lawyer and executive director of the Internet Freedom Foundation, explains more on how traceability can breach user privacy.
Messaging on social media to some extent is protected by a technology which is called encryption, which is deployed most commonly when you send a message from your phone to another phone, for instance in WhatsApp. Here, WhatsApp does not know who sends the message and cannot read your message by itself. This keeps the message private when it is in the course of transmission, and in fact ensures the confidentiality, the privacy of the conversation. However, the government wants to change this and has in fact changed it. Traceability as a requirement where the originator of any message is fingerprinted to each message. So imagine each time you're composing a message and sending it on WhatsApp, it is tied to your phone and your number. And this can be traced back to you. Doesn't that make you feel insecure? And doesn't that undermine your privacy? And this is on top of already the scant amount of privacy protections which are not there. India does not have a data protection law, and a lot of your existing metadata, for instance, which groups you're part of, what's your sign-in details, are already there with WhatsApp. So add it with your conversation data now, and in a sense, a lot of what you do online is now transparent and available potentially to the government and police departments. And this comes at a time where more people are taking to platforms and social media quite often to voice political opinions across the spectrum.
But what does the government say about why it wants traceability from social media platforms? For a long time now, since the government started working on tightening the rules for social media platforms to increase accountability, it has categorically been telling WhatsApp that it wants the messaging platform to enable traceability. The initial demands came up because of the fake news menace that had triggered mob lynching and more than 40 deaths in India around 2017 and 18. If you remember some of those incidents, misinformation about child kidnappers was circulated on WhatsApp, and that had led to violence in a lot of states like in Assam, West Bengal, Gujarat, Rajasthan, etc. And since WhatsApp has around 390 million users in India, these cases of fake news leading to mob lynching led the government to ask for accountability. And WhatsApp took some measures of its own, like putting a limit on forwarded messages, but the government insisted that it wasn't enough. It said that WhatsApp needs to enable traceability and assist in criminal investigations. But the messaging platform has been resisting that demand because it would affect the end-to-end encryption. While the government can argue that this demand is for accountability or to perhaps dispel fake news, what is the real concern with the centre's mandate? Mishi Choudhary, lawyer, legal director and founder of the Software Freedom Law Centre, says that the concern is that there's a trust deficit about the government's intentions. There's a deep suspicion that the government might use traceability as a tool to control the narrative, she says.
I think first there is a trust deficit about the intentions of the government. We have seen that the government has been asking to take down a lot of handles on Twitter. We have been seeing content removal is happening whether it is about farmers' protests, whether it is about people criticizing government's response to the pandemic, or it is about other people talking about the variant of the coronavirus which was first detected in India. Government has been coming out really in a heavy-handed manner in order to control the narrative. That also raises the suspicion, why do they want to really use these rules? That people are rightly suspecting that these rules will be used for censorship by proxy, which is that the government itself does not censor but just tells the company to censor. So there is a big trust deficit here.
Why the government's demand is also raising rightful suspicion, Ms. Choudhary points out, is because of how it reacted to the manipulated media tag on the toolkit posts shared by BJP leaders.
Second thing is, as we saw, these rules themselves require these platform companies to label any information which may be patently false. So, a few days ago, when Mr. Sambit Patra, the BJP spokesperson, shared some manipulated media, which was called the Toolkit, and Twitter labeled it, we saw there was a raid at Twitter's office. And the government, out of nowhere, trying to represent Mr. Sambit Patra, who's a citizen and has no business interfering in between Twitter and him or how Twitter conducts his business, sent a letter to them. Now, that means when it is your own BJP functionary who is at the receiving end of what you require from the law to do, you are going to turn around and say, oh, why did you follow that law? But otherwise, you want people to follow that law. So, that hypocrisy of the government is why nobody wants to actually believe that these rules, which are ostensibly passed to check misinformation or fake news, mean that somehow government is actually going to do that. Because a lot of this fake news and misinformation can be traced back to the IT cells of political parties.
So there's a lot at stake here for users if WhatsApp loses the lawsuit, she explains.
What is at stake is that ability to communicate freely, saying anything to each other, to your family members, to your lovers, to people you don't like, without the fear that somebody is going to be able to trace back that message. That is going to go away. If I, for example, shared some message just to check whether it is, to verify whether it is right or not, or if I shared or forwarded a message and somehow it can be traced back to me and there can be a misunderstanding about whether I was the actual originator of that message, whether I wrote that message, or what was the intention that I shared that message, that confidence is going to be taken away from the users. So if police can tomorrow, under a misunderstanding, land up at my door and say, Mishi Choudhary, you wrote this message, you are originator number A, and originator number STUVWXYZ, all we have come back and they have traced it back to you, you are under arrest. But actually what had happened was that I had just taken the message which for some person called C had written, and I had only thought it was interesting and forwarded. Then I'm now stuck. And we see how the procedure is a punishment in our country. Now we are making all that impossible for people to freely communicate. The second part also is that now companies will be forced to modify their existing tech infrastructure, because otherwise they really can't get any access to what kind of information police might demand. And they have to now keep all our communications and store every kind of communication, because they don't know, maybe 6 months down the line police might ask a question. So the principle of privacy, which is called data minimization, that collect minimum amount of data for me, is clearly violated. The third thing is, in all of these cases, there's been no transparency at all. The government issues orders under Section 69. They are secretive orders. We do not know when content is taken down. We do not know when an investigation has started. So then this entire looming cloud that something is happening is at stake. So I would say that the private communication, which all of us have now come to rely on, we conduct our lives on it. We have video chats, people have lovers chat, husband and wife who have who are in different cities chat, families talk about sensitive matters like finances, like property, people talk about school, businesses talk about matters like this. All of that is now under a threat.
And that's not the only problem with the new IT guidelines. The general issue that experts have raised is that the rules lack clarity and transparency and can stand to threaten the freedom of press and privacy. Take, for instance, the other requirement of appointing a grievance officer. Rules 10 and 11 of the IT regulations now mandate every intermediary to appoint a grievance officer and redress all grievances within 15 days. But there's no definition of what kind of grievance or what is the limitation to what is going to be considered as a grievance. Will it be everything and anything? Without clarity on this law, will it not negatively impact the freedom of media? Mr. Gupta lays out some of the other criticisms around the intermediary rules.
These compliances impact two of your most cherished fundamental rights. The first is your fundamental right to freedom of speech and expression, and the second is your fundamental right to privacy. Without both of them, it becomes very hard for you to actually participate in the larger well of public conversation which takes place on social media today. Now, these compliances specifically are towards appointment of grievance redressal officers where you can send complaints if you don't like any kind of content. Now, this is all well and fine, but these appointment comes under certain other conditions which make the exercise of these rights very difficult and burdensome for platforms. And this then has an impact on you and the kind of statements that you make online. Now, let's just look at it a bit closely. The first is that you can send a complaint to them, but you can also send a further request to them under their rules, and you can go to a police station. Now, if the complaint is not acted upon in a reasonable period of time under these rules, as it has been determined, to acknowledge the complaint, which is 24 hours, and to resolve it within 15 hours, and you go to a police station, the police can not only arrest the person who sent out the tweet, but also the platform itself, which is Twitter. So essentially, these rules changed the game, how the platforms were availing immunity and bring in compliances under these short timelines in which they need to act. And for a second now, imagine that it is not you who is filing a complaint, but somebody else is filing a complaint against you. The final part which is concerning is automated filtering and takedown of messages. Automated filtering is when an algorithm is deployed to clean your social media using keywords such as text-based filtering or even through photo or video DNA basis. Now, this has been applied only in restricted categories such as child sexual abuse material and does not seem to be problematic on its face. And this requirement, is in fact also asked for by certain members of civil society. But here lies what is called as a function creep. The requirement also comes with an added innocuous statement that any content which has been taken down should not be re-uploaded. In a sense, every social media company will need to maintain a consolidated list of what material has been taken down in the past, which may be not only child sexual abuse but any other material, and prevent its re-upload. Now, what is this problematic is quite often these algorithms do not know the context. So if a certain picture which is illegal has been taken down because people have been supporting a certain thing within it, and you take that same picture, for instance, a person objecting to a Nazi salute, which is a historical picture, and that algorithm deploys it in a manner where you are essentially criticizing that point in history or using that historical footage for any purpose, the algorithm will be context independent and will flag and censor it. This will result in a chilling effect. This will also lead to removal of large amounts of material on social media today.
But as WhatsApp challenged the centre in court, in a press statement dated 26th May, the government asserted that it respects the right to privacy and doesn't intend to violate it when it asks WhatsApp to trace the originator of any particular message. It is only intended for quote-unquote prevention, investigation or punishment of very serious offences, the press note says. While it said that the last-minute lawsuit from WhatsApp was unfortunate, the note from the IT Ministry also asked all the companies to give information on the status of compliance ASAP. Since then, Facebook and Google have indicated that they will be assigning grievance officer to comply with the new rules, but Twitter's stand is still unclear. If you like listening to this episode, please subscribe to the Big Story playlist for episodic updates. We're live on Apple, Google Podcast, Spotify, JioSaavn, and most of the other popular podcast streaming platforms. For other podcasts, please log on to the Quint website and check out the podcast section For any feedback, shoot an email to podcasts@thequint.com.
Thanks for listening. Log on to the Quint's website and check out our other podcasts.